This next section is on Chapter 7 of the Bankruptcy Code, liquidation proceedings. This is the chapter most folks think of when they hear bankruptcy. This is where we're liquidating or basically wiping out everybody's debt. If it's a business or a corporation, when you liquidate, it's gone, right? It goes out of business. With a debtor, the debtor does get to keep some of their assets, so they're not 100% totally wiped out, but they're basically given a fresh start. So liquidation occurs when the debtor turns over all of their assets to a trustee, who we'll talk about in a moment, who then sells the non-exempt assets and distributes the proceeds of the sale to all of the, well, among the creditors. Not all creditors will get paid. So who is eligible for Chapter 7? Well, first, this means test. This is new. Well, new. This is one of the amendments to the 2005 bankruptcy code that we now are using. Didn't have a means test before. Basically, a means test, and I'm going to go over that in more detail. Means or is a way to determine whether somebody has disposable income, which then in turn can be used to pay creditors. So, one, to be eligible for Chapter 7, a person has to pass the means test. No prior discharge of a bankruptcy proceeding. Again, like I said earlier in the last video, there was no limitation. You can just file every year, every 2 years. No prior discharge. So now you have to show that you didn't have a Chapter 7 discharge within 8 years or Chapter 13 in 6 years. And you have to show that you haven't been subject to a dismissal in the previous 180 days. So let's talk about this means test in a little bit more detail. If someone doesn't qualify for a Chapter 7, and usually that's because they haven't met the means test, their petition is subject to dismissal. One who fails to meet it, your petition could be dismissed, or if it is a means test issue, it could be converted to a Chapter 13, which we'll discuss in the next video. So the goal of the means test is to determine whether our filer or our debtor can be forgiven through a Chapter 7 bankruptcy. So this means test takes into account income, expenses, how big the family is, to determine whether or not there's any sort of disposable income that will be available to repay debts. Although it was designed to restrict a number of debtors who can get their debts forgiven through a Chapter 7, most people actually meet this test quite easily. So how does it work? It's actually a two-part process. I shouldn't say it's a two-part test. It's actually, there's step 1. If you meet step 1 and you're within the means test, you can file for Chapter 7. If you're above the threshold, then you have to go to step 2. So step 1, the first part of the means test, checks whether your household income is below the state's median income. And each state has a different medium depending on what the bankruptcy laws say at that time. This number will change. It doesn't, I don't think it changes annually, but it does change regularly. So the average household income is determined by averaging your monthly income over the last 6 calendar months. This means test is based on the past 6 months, so there are adjustments for recent and upcoming changes. So say you had a job for 4 of the past 6 months but are now unemployed, the means test will factor in the drop in income. Conversely, you recently got a new job and are making more, and that increase will be considered as well. As of 2025, there's the New York median income numbers. If you are one person member household, 66,824, and that's actually a drop from 2023. By the way, I looked at, well, I teach this every year, every spring semester, so I always tend to look at the numbers, and in 2023, that number was actually a little higher. I had to double check. So, but the other 3 have gone up. Household of 2, household of 3, household of 4, and it goes beyond that. I didn't list any more here. So if you are a household of 1 and your monthly income over the last month falls within that annual category. You have to divide it by 2. You have to do the calculation for an annual income, medium incomes. But if you are under the 66,824, you have passed the means test at this point and can file for Chapter 7 bankruptcy. But if you are above, you have to move on to Step 2. In Step 2, monthly income, and we're taking your monthly income and we're subtracting your reasonable living expenses over the past 6 months. Things such as rent, groceries, clothing, medical costs, they all make up what's called the allowable expenses. And what's left after allowable expenses is deemed disposable income that could be put towards paying off the debt. So you multiply this number by 60 because we use 5 years for Chapter 13. I'll get to Chapter 13 in a minute, but our 5-year cutoff for repayment. So we use 60 months here because, as I said, if you have disposable income and you don't meet the qualifications for a Chapter 7, a court can push you into a Chapter 13. So that's where we get this 60 months from. So you multiply your number by 60 to determine income available over a 5-year period for repayment of the debt obligation. What's allowable is based on we have a national and a local standards that are used by the IRS. The national standards cover items like food and clothing, while local standards cover expenses like housing and car payments. So I'm not going to test you on calculations. You just need to know what the means test is. We're not going to go into whether a person meets it or not meets it. You need to know they have to meet a means test in order to qualify for a Chapter 7. So since we're talking about Chapter 7, let's say our debtor has passed the means test and our court is now going to issue that order of relief, because this is where we do the means test, is to determine before the court says, hey, you don't have to pay your debts. So this means test is happening right before the court issues the order of relief. So our person has passed the test, they will get their order of relief, and we will move on to the next step. The next step is a creditor's meeting. So within a reasonable time after the order of relief is granted, it's not less than 20 and it's not usually more than 40 days, the court must call a meeting of creditors. At this point, a trustee is also appointed. The debtor must attend and submit to an examination under oath. They're examined by the trustee and creditors. They're asked questions about their debts, any of their financial affairs, anything on the petition. They try and find out if there's anything missing from the petition or if the debtor is trying to conceal anything. All of that is happening at this meeting. If the debtor fails to show or found to have made false statements, their request for discharge or relief could be denied. They can also be charged with perjury, but we won't go down there. Also at this meeting, the trustee ensures that the debtor is aware, again, of the consequences of bankruptcy and the availability of any other forms or alternatives. So that also happens at this meeting. Let's talk about the trustee. The trustee has duties and they also have some powers. The trustee is who the court authorizes to take control of the debtor's property and assets. Their first job is to determine whether the debtor's financial situation warrants relief. Based on what they do is they compare the debtor's income with the income of other families in the same state. They also make sure the means test was met. After the meeting, the trustee is tasked with selling the debtor's assets and then distributing the proceeds to the creditors. Some of the duties, they are accountable for basically administering the debtor's estate. They collect all the property, especially all the property that's in the hands of the debtors and any property that's held by third parties. Maybe the debtor let somebody borrow their ATV. That would have to be returned. The trustee has the ability to get that. They're also allowed to take any property and reduce it to money, so selling things. They also have to preserve interests of both the debtor and creditors, unsecured creditors. Secured creditors we'll talk about in a little bit. When trustees take possession of property, they can have it appraised. They also examine the debtor's filings and any records. They may take over a debtor's business. If they're a sole proprietor or corporation, they can take over the business. They have to be the ones to separate the exempt property from the non-exempt property. They're required to keep careful records of the property and the sale of the assets during the process. So the trustee has a very big job in this proceeding. They also have a lot of power. They have the power to sue and be sued on behalf of the debtor. So they can sue on behalf of the debtor if they need to get, if somebody owes the debtor some money, they can sue to get that or get the return of property. But they can also be sued by those third parties who think that the trustee is abusing their power, overstepping. So they can be sued as well. They can assume or reject contracts of the debtors. They can expire leases. They have the right to obtain credit on behalf of the debtor. When we're talking about a business or a corporation, they have the ability to go out and do that. They won't do that for an individual person. They have the right to void liens against the debtor's property. So a mechanics lien filed against a homeowner, they could cancel that right on out. They can also void any preference. So let's say a debtor is favoring one creditor over another. Maybe the debtor likes their yacht, so they're paying that bill, but they're not, paying another creditor's bill. They can certainly avoid that preference and recover any payments. They can transfer or cancel. They can cancel any fraudulent transfers that are made by the debtor within a 2-year period of that filing. And I will get to a couple of examples on some of these. So let's say a debtor has an exempt home property. We're going to talk about what's exempt property, but a home is very likely to be an exempt property. But let's say it's hindered by a mechanics lien. The trustee can void that lien in favor of the debtor. Let's say Mary's planning to petition for bankruptcy, so she sells her gold jewelry worth $10,000 to her friend Diane for $500. Diane agrees that in the future she will sell the jewelry back to Mary for the same amount. Well, the trustee might think that's a fraudulent transfer and cancel it and demand that jewelry to be returned. So let's talk about some exemptions. Property that does not go into the estate. The debtor is entitled to exempt property, some certain exempt property. Why do we do this? Well, so they're not made destitute or poor. We're not just going to wipe them all out and they have nowhere to live. They don't have any clothes. They don't have a car to get to work. So there are some exemptions. And despite the Constitution's mandate that Congress shall establish a uniform bankruptcy law, states have convinced Congress to allow for non-uniform exemptions, meaning states can pass legislation to prevent debtors from using federal exemptions, and a majority of states have done that, including New York. So there are some states, though, that give the debtor options. You could choose to use the federal or the state. There's some that are just, you're using the federal, we don't want to get involved. And then there are states that you have to use ours over the federal exemptions. Why this? Why did Congress allow this? Because think about it. If you live in New York State is a very expensive state to live in. Maybe not so expensive to live in other parts of the country, maybe in the Midwest or the South. So using a standard federal exemption could hurt some people while help other people, right? In the end. So it's not really fair. So in New York, the debtors actually get to choose which exemptions to use. So there are a certain number of exemptions that one is entitled to, and the exemptions are monetary in nature. The homestead exemption, let's just start with that one. And by the way, this is not an exhaustive list. There's many others. These just are the most common ones that come up. Homestead. Folks will say, oh, I get to keep my house. It's not necessarily true. You get to keep a certain amount of equity in your residence. That amount of equity depends on where you live. Let's take New York State. The cost of living in New York State in the northern part is certainly a lot less than in the southern part of the state, or possibly even the western part of the state. So the New York State exemptions are actually listed depending on where you are in the state. You get more amount of equity in Long Island than you do in Plattsburgh. So if you own your home outright, and let's say it's valued at $200,000, there's a very excellent chance that you're going to get to keep your house. But if you own $1 million home in Plattsburgh and you own it outright and you're only allowed to take an equity in that of $250,000, then you're going to have to sell your house and take the $250,000. That's how the exemptions work. Motor vehicles, same thing. A certain amount of money in the value of your one personal vehicle, not your classic car sitting in your garage. There's household goods, furnishings, the clothes you wear, appliances, pensions. These are capped. Let me take that back. IRAs and Roths are capped. There's tax there, but there are tax exempt accounts that are not. So those would have to be specifically laid out. Public benefits are exempt altogether. Alimony and child support are exemptions as well. So the next step, the creditors' claims. Within 90 days of that meeting, creditors have to file a proof of claim. So what's a claim? Well, they're claiming they have a right to money, right to payment. Who's a creditor? Well, one who has a claim that arose no later than the order of relief. So borrowing money from your neighbor last year for $5,000, you haven't paid them back, they would be considered a creditor. If they file a proof of claim, they'd be on the list. They have to provide a name, address, and the amount that they say is claimed. If they do not file a proof of claim, they get nothing because they haven't shown their proof of claim. You may have listed on your debts in your petition, but unless they come forward with, here's my proof of claim, not going to get anything. I will note that even if a creditor files a proof of claim, there's no guarantee that they're going to receive a payment. When a trustee is sorting out and examining property, they're going to be determining whether a creditor has a secured interest in debtor's property, and the debtor may even decide to give up that property to the creditor in hopes of satisfying the debt. They bought a boat and they can't pay for they lost their job, they had to file for bankruptcy, they can't pay for the boat, they just, here you go, have at it, take the boat. The priority among our creditors, secured creditors, unsecured creditors, both of those categories have a list of priority. As we learned about secured creditors, there's that idea of they've perfected and put everyone on notice of their claims, but they don't have equal claims. So I'm going to note that the highest priority creditor is going to be domestic support above anybody else. That alimony, that child support, that's going to get paid first. So after domestic claims, the next are these valid security claims. Like I said, the debtor can surrender the collateral in full satisfaction of the debt. Sometimes that's the deal the debtor wants to make. Here, take the boat in satisfaction of everything, and I don't see you again, creditor. However, if the collateral is given back to the creditor without any sort of, it satisfies the debt, and the creditor takes that boat, I'm going to use that same example, sells it, but it doesn't, and it leaves a balance, the debtor is still going to be owed, is still going to owe that balance. The creditor is still going to be owed it. The debtor still has to pay it. And that balance will now be turned into a unsecured claim. So that'll go to the bottom of the food chain. So most of the time, the debtor is better off surrendering the collateral in full satisfaction. But those are the options relative to secured creditors. So Sandy Claus Corp., a toy wholesaler, was petitioned involuntarily into bankruptcy under Chapter 7 on July 21st, 2011. Keebler Inc. has perfected a PMSI in some toys that it has sold to Claus. Claus owes Keebler $30,000 and has not been paying Keebler or its other creditors' debt, and now they're all come due. When Claus's assets are liquidated, the toys sold for $40,000. How does this get distributed? Well, Keebler gets paid in full, $30,000. And then the balance, the trustee will have to pay off to those general creditors. Our unsecured creditors, those are kind of the lowest ranking class. We find our neighbors who lent us money in this category. Credit cards fall in this category. Most of the time, they receive nothing. There's no money left at the end of the day. Maybe they get a portion, but usually there's nothing. And if, on the flip side of that, if all creditors are paid and there happens to be a little bit of money left over, that gets returned to the debtor. The whole point of bankruptcy is for the debtors to get relief from the pressure of debt that they cannot reasonably pay. Once the proceeds that have been distributed, and the debtor usually has remaining debts. That's usually how it is. I've never seen a surplus, but maybe that has happened. But the debtor's remaining debts, they are now discharged. So what does that mean? The debtor is no longer legally liable to pay any remaining unpaid debts that arose before the court issued the order of relief. The discharge itself voids any money judgments, those judicial liens, against the debtor, and bars any of the creditors from seeking judgment. That's it. Bottom line, this discharge is only available to what we call the honest debtor. So acts that will bar discharge, speaking of honest debtors: false claims, concealing property, transfer of property after filing with intent to defeat the law, as we say it. Okay, fraudulent transfers. Refusing to obey court orders, destroying, falsifying books or accountings, failing to file satisfactory explanations for any loss of assets, individual abuse of the bankruptcy process. We need a finding of bad faith in that regard. So these things will bar any discharge. There are debts, though, that are specifically stated in the code that are non-dischargeable. Again, not an exhaustive list. These seem to be the top ones that come up. All debts not listed on the petition. If you don't list it on the petition, you're still going to owe it. Student loans, unless an undue hardship is shown. Taxes, fines for violating the law, alimony, child support, divorce, any of that not dischargeable. Debts for personal injury caused by DWI, liability due to theft or embezzlement, debts arising from fraud, and violations of securities laws. Obviously, this last one kind of relates to business companies. Think of Enron. So these are debts not dischargeable regardless. The only one, there's the exception for student loans, but there has to be a finding of an undue hardship. One last point I want to make here, revocation of a discharge. Even if the debtor receives a discharge from paying their debts, it can be revoked within 1 year. The trustee or the creditors discover that the debtor committed a fraud during the bankruptcy proceedings, unknown to the trustee and the creditors. Either one, the creditor or the trustee, can seek a revocation. So the court can revoke that discharge within 1 year of ordering it. So if we have a debtor that conceals assets in order to defraud creditors, that might be grounds for revoking the discharge in bankruptcy.